and welcome to our today's webinar on data transfers after Schrems II, a new iron curtain for data. This event and online webinar is hosted by Vilnius University Law Faculty, and we are truly privileged to have a rock star lineup of speakers today. My name is Paulius Jurčys, and together with my colleague Goda, we will be helping our members of the seminar to participate in this event. Our first speaker will be Marcelo Corrales, who is a rising star in data privacy. He has obtained his PhD in Japan at Kyushu University, and he also holds a couple of master degrees from Japanese university and the university in Switzerland. Marcelo will talk about Schrems decision and share some of the insights about its impact. Our second speaker is Dr. Magdalena Goralczyk, who is also leading data privacy expert. She is working as a consultant to large and very large corporations in Europe that are trying to comply with the Gdpr. She's also consulting governments on similar matters. And our third speaker is Kiviluoto, who is the CTO of a data technology company in San Francisco, and has been also holding many leadership roles in data science. So we are really looking forward to your presentations. And yeah, maybe Marcelo could start by his presentation.
Yeah, sure. Thank you, Paul. Thank you, Goda, and thank you everybody for being here. So I will start this presentation by introduce you who Max Schrems is. For the people who don't know him, this is Max Schrems. He's an Austrian citizen, and therefore he's also a citizen of the European Union. And this whole Schrems saga started when he was very young and he went to the US as an exchange student. He spent 6 months in California. He was taking some courses there. And basically one of his professors mentioned to the whole class how bad American companies were treating personal data of European citizens. And the professor also said that in Europe, they have very good laws, but nobody really cared about enforcing them. So they didn't know that there was an European citizen sitting there incognito. And you could say that this is the moment where Schrems took it a little bit personal. And yeah, he decided to find out whether it was true or not. So as you may know, there are all the big tech companies, basically American big tech companies such as Google, Facebook, Microsoft, LinkedIn, and so on. They all have branches in Europe, and for taxation reasons, they decide to go to Ireland because they can pay less taxes there. So the whole Schrems case is about one of these big tech companies, which is Facebook. Right, and according to Max Schrems, the law and the practice of the U.S. was not really adequate to the practices that we have in Europe. So it's not really protecting the privacy rights of individuals because of the surveillance laws that they have. And yeah, so he decided to file a complaint against Facebook. And that was already in 2013. This is the Schrems I case, because every time that you use Facebook in Europe, you need to transfer data from Facebook Ireland to the US. So you perform some sort of data transfer there, right? And he asked the Irish Data Protection Commissioner to stop or suspend the data transfer. And the Irish Data Protection Commissioner rejected the petition based on the previous safe harbor agreement. So basically they say, I mean, the data transfer is legal because there is this safe harbor agreement between Europe and the US. So Schrems challenged that, and he went to the Irish High Court, and the Irish High Court sent these questions to the European Court of Justice, and the European Court of Justice finally invalidated the framework, the framework between transferring data between Europe and the US, which was the Safe Harbor framework. So this is a little bit of the background story with Schrems I, right? And there are basically different aspects and levels of privacy. One of them is this idea that we have of surveillance, and this has been very clear in the Snowden case, where he revealed how, for example, the National Security Agency in the US, the NSA, is tapping on citizens' data, right? So the whole Schrems is all about this surveillance issue by public authorities in the US. So you can imagine that this is also a highly political problem. Right. So we also have a lot of surveillance through big tech companies. As you can imagine, all our mobiles are basically run by one of these big tech companies, all our mobiles, iPads, and so on, right? So if you are the NSA, the National Security Agency, for example, you don't really need to go to all the data of the citizens, right? But you can just go straight to one of these big tech companies. And this is why they came up with these kind of laws, such as the Patriot Act and also the FISA amendment in Section 702, where they can basically use the sort of terrorism argument to fight against terrorism argument to tap into all these personal data. Right? So after the failure of the Safe Harbor framework, they decided to improve this, and they came up with a whole new framework, and they call it the Privacy Shield, right? And the Privacy Shield was based on 4 main pillars. One of these pillars is basically they put more obligations on companies, and which was more rigorous, and they tried to create more transparency. And this was very similar to the previous scheme that we have, meaning that they could have like a self-register participation there. They had annual renewals, and if they didn't honor the privacy principles there, they will face some sanctions, or they will basically be excluded of the framework. So that was the first pillar. The second pillar, they basically created more limitations for the companies, and also some supervision mechanism. And then the third pillar, they created more levels for redress possibilities for individuals. And they also created different mechanism, for example, an alternative dispute resolution mechanism, which was for free, also arbitration, and so on. And then the fourth pillar, basically they say, okay, every year we're going to join, have a meeting with all the stakeholders, the European Commission on the one hand, US authorities and different stakeholder groups, and we're going to analyze whether this is working, and if not, we're going to try to see how we can improve this, basically. So this is in a nutshell what the Privacy Shield was about. So as you can see, there were a lot of expectations about this, and this is what Vera Jourova, the former European Union's Commissioner for Justice, Consumer and Gender Equality, said. She said the Privacy Shield will restore the trust of consumers when their data is transferred across the Atlantic. So this is what she said, and this is Max Schrems' response on a tweet, and he said, they put 10 layers of lipstick on a pig, but I doubt that the court and the data protection authorities suddenly want to cuddle with it. And you can see the picture here of a pig with a safe harbor scheme and with a lot of lipstick, and all the little piggies are the big tech companies there. So this is his reaction to this whole new framework, right? So this obviously led to the second round of Schrems, right, which is a court decision in Schrems II that came up in July last year. The court decision is really long. It has like more than 100 pages. So I tried to summarize in 4 bullet points what this whole court case is about. So basically, what they did there is that they invalidated the EU-US Privacy Shield framework. So you cannot use that anymore. But you can use instead the so-called standard contractual clauses, and we will see in a minute what they are. And basically, it requires a case-by-case assessment whether you can actually use the standard contractual clauses. And this is when you want to transfer data to a third country. And in this case, you can also use it to transfer to the US because they struck down the Privacy Shield framework. And there are two major issues here. One of them is the third bullet point there, which says the controllers and processors exporting data need to verify if the law of the third country impinges on the effectiveness of the appropriate safeguards contained in Article 46 GDPR. And the last one says that exporters need to implement supplementary measures to fill the gaps and bring it up to the level required by the GDPR, basically. So the big question is, what are these supplementary measures? Because the court decision didn't really mention what exactly these measures would be. So this is the Schrems II case, very shortly. And as you may know, we have some legal frameworks to transfer data in the General Data Protection Regulation, and this is what you can read in Article 45, 46, 47, and 48. And very, very quickly, because we don't have too much time to go into all the details, there are 3 levels of data transfer. The first one is the adequacy decision, which is basically a list of countries that have the same level of data protection. And the countries, you can go to this website and you will see an updated list there. And at the moment we have 12 countries. There used to be 13 countries counting the US with the Privacy Shield framework, but it was invalidated several months ago. So now we have these 12 countries, right? So if you want to transfer data from Europe, for example, to Japan, or in South America, you have 2 countries like Argentina and Uruguay, you can transfer data safely in the same way that you transfer data within the EU or the European Economic Area, right? So that's the first level, which is the most important one. This is in the top of the pyramid. Now, if you want to transfer data to countries that are outside of this list, for example, if you want to transfer data to Paraguay, where I originally come from, and then you have to go to the second level, and you have different options there. One of them are the so-called binding corporate rules. This is when you belong to a group of companies like Google, and you want to transfer across the subsidiaries, and then you can use the binding corporate rules, but they will need to be authorized by the Data Protection Authority. But the most important mechanism here are the standard contractual clauses, right? Which is what all this case is about. And basically what it means is that the European Commission, they created some standard contractual clauses that you can download from the website and use them directly in your data processing agreements, right? Or you can come up with your own standard contractual clauses, which is this one here, the so-called ad hoc, but they will need to be authorized by the Data Protection Authority. So that would be the second level, and the third level is when the adequacy decision or appropriate safeguards are not available, you can use the so-called derogations. For example, you can use consent. Now, the problem with consent is that you cannot really use it on a regular basis and only on specific occasions. So in practice, the derogations are not very useful, they're not very practical. And this is why all the companies are relying on the standard contractual clauses right now. So that's a little bit of the legal framework. You have here, this is just a chart flow, which explains against the 3 levels, right? If you want to transfer data and there is adequacy decision, and if yes, then you can transfer the data. If not, you have to go to the 2nd level, which is the adequate safeguards, such as the standard contractual clauses, or you have the derogations. So you remember that one of the things that happened in this case was that you need to implement supplementary measures, right? If you want to transfer data, for example, to Paraguay, and maybe you think that in Paraguay, the data protection law is not very good, and then you need to add supplementary measures. So everybody was wondering about what exactly that means. So the European Commission, and more specifically the European Data Protection Board, they came up with some recommendations that they were adopted in November last year. And they established a 6-step process. And very quickly, I will just mention the 6 steps. Basically, step number 1 means that you have to know your transfer. You have to know exactly which countries you are transferring data. These include own work transfers, for example. And this is not very easy, especially in a cloud computing environment where you may find different kind of cloud service providers. And even if you want to use them for backup or any other kind of storage purposes, and then is for all the companies not very easy to know exactly where all these servers are located. So step number 1 is know your transfer, right? Step number 2 is say that you need to identify which mechanism of data transfer you are relying on. And these are the 3 levels that I mentioned before, either adequacy decision or the derogations or the standard contractual clauses, for example. So step number 3, this is where it gets a little bit tricky, because it says that you need to assess the law of the country where you want to transfer data. And you have to do it in collaboration with the data importer. So let's take the Paraguayan example again. If you want to transfer data to Paraguay, that means that you need to read the data protection laws in Paraguay. And that means that probably you need to speak Spanish as well. And you need to know the practices and what is exactly going on in Paraguay. For example, whether there are similar data subject rights or whether they have any kind of surveillance law, such as the Patriot Act in the US. And so this is where it starts to become a little bit complicated from a practical point of view. Step number 4 is probably the most crucial one, because here they're supposed to highlight the supplementary measures that I mentioned before. And yeah, so this means that if, for example, following the Paraguayan example, you realize that, okay, maybe Paraguay, they don't really have very strong privacy laws, right? So we need to add supplementary measures. And you can do this in 3 ways. 1, from a contractual point of view. 2nd, from a technical point of view, which is probably the most important one. And here you can use, for example, pseudonymization or encryption or homomorphic encryption. And this is probably what is going to be the most useful mechanism for you. And then you also have organizational measures. So that's basically step number 4. And then finally, you have the step 5 and 6. Step 5, it says that you have to take into account any kind of procedural steps. For example, if you are going to use the ad hoc standard contractual clauses, that means that you will need an approval from the Data Protection Authority, for example. So you need to check all the procedures that you need. And finally, step number 6, it says that you need to monitor and reevaluate the level of protections on a regular basis. For example, in the case of Paraguay, that means that you need to check whether there is a new law there or a new practice or a new event that trigger and change the landscape of the data transfer that you were doing before. So these are the 6 steps, and this is basically the framework that we have. In theory, this all sounds good, but in practice, I think Magdalena and Kimo later on probably are going to disagree with this, that this is basically very complicated for companies. And I will leave you with a final tweet from Max Schrems about the supplementary measures that we discussed before. Basically, he said, there is no supplementary measure that you can put on a piece of paper to make a US company that has factual access to the data ignore, for example, the FISA 702 that I mentioned before. Yeah, and the only supplementary measure that can fix that is that is in the hands of the US legislature. So basically what he's saying is that the US government has to step back and change their surveillance laws that they have, and that's the only way that we can actually have supplementary measures. So I will stop here and I will pass the floor on to Magdalena. Thank you very much. And we will keep the discussion later on. Thank you.
Okay. Super. Thanks, Marcelo. And I absolutely love where you finished, because in a way, it just really opens the floor to me talking about, you know, what I think is the tragedy of all of this, really. And that is not, you know, that it basically is useless. If I can bluntly say so. Give me a second. I will just share my slides properly with you. I hope you can see them, and we are back. So I have one thesis here that I will try to argue through my own slides, but mainly from the slides that Marcelo shared, which is basically that the Schrems II decision brought a formalistic, extreme formalistic burden on the organizations, so on all the companies, while in no way increasing practically the protection given to data subjects. And I think in some sense, probably, I don't know if Marcelo would agree on this, but I think Max Schrems probably would, because basically that's very much what he says when he says this. Because what happened here is basically that, you know, the courts have said, okay, we can't go all the way through. We can't kill SCCs because it would have an economic impact that we cannot control and we can't live with, but we can't just let it be. So we are going to put a lipstick on a pig, if you want to say so, and we're going to say, hey guys, you in the companies, you are now responsible for what we have not managed, meaning you have to assess what's the actual level of protection of companies, of data, when companies transfer it out of European Economic Area to somewhere else. And the beautiful proof of how difficult it is this list exactly. So European Commission has managed since the directive is in place to go through and grant this many adequacy decisions. Congratulations. And now what happens is that we are saying, hello, companies in Europe, if you do SCCs, which is the only realistic way to transfer data outside of the European Union on a continuous basis, if you are working with providers, if you're working with other companies and not within the group company, it is your job to check the law and then to do something about it. So this is absolutely beautiful because you can see, okay, commission with basically thousands of people with, you know, millions, if not billions of euros of our taxes manages to do that. And then everyone says, and now you, company X, and we'll speak about the company X in a second, should do this by yourself with your legal team of, let's say 5, maybe 10, maybe 50 people. How realistic is that? So thank you, Marcelo, for preparing the slides. I am very grateful for that. But let's take a step back. What's data protection? So data protection is being told to be a human right. It's a human right of you and I, to have an important part of us, which is the data that are produced based on our existence and the way we go through the world, protected. At the same time, it's a very specific right, and you'll have some very cool researchers to talk about it as the so-called procedural human right, because it brings a lot of formalistic obligations towards companies at large. Now, the problem is those obligations might not always be wrong. They might sometimes, at points in time, really increase the protection given to individuals. A perfect example, automated decision-making. If you're doing automated decision-making and you're able to document and explain how you have done so, you've actually truly increased the level of protection you are giving to individuals. Is that the case in this beautiful example that Marcelo has just brought? So here we have this beautiful transfer impact assessment. My argument is absolutely not. And why is that the case? Well, it's just because reality is this can't work. If it didn't work for European Commission, how can this ever work for a normal company? And when I look at this, we look at this and we're like, okay, so the company has to sit down and map their data transfers. And everyone is speaking about GAFAM. So the big companies, being big in Europe, being even bigger in US, earning billions of data. But what we are speaking here practically is, a consulting business like mine with 10, 15 people, a European company, which might be slightly larger and maybe have 2,000 people, maybe a startup, maybe even, a municipality. All of those companies, and I love to ask the crowd if any of you does, but how many providers do you think a typical company has? If someone dares to answer, then go ahead. Okay, but then I'll just say, and it's even hugely written in the screen, so you don't really have to guess much, but a semi-successful startup will typically have maybe 100, maybe more IT systems. Today, all of the IT systems that we use, you no longer build something, you no longer get it, on a CD, put it in your computer. No, everything is software as a service. So in order to run a business, you will outsource everything. You will have an HR platform. You will have your cloud. You will have a CRM system, etc. So it goes in hundreds with smaller companies. If you are a large insurer, a large bank, it goes in thousands. So you need to understand that this beautiful table and the mapping is done for thousands of providers in worst case. And that is not the data flows. The data flows will then multiply per provider. So you're doing this mapping, and that's still fair enough, because in principle, as per principles of GDPR, you should do this mapping anyways. And it's a good thing. You should know where your data is, with whom, you should have your contracts in order. But then what happens next is, you're quite clearly, identifying mechanism used. And that's simple, because in principle, 90% will be SCCs. There's just simply no other way today. I've done 2 BCRs for 2 different companies, but that's something that you can establish as your own framework within your own group of companies. If you go outside of that, if you want to, you can't have a BCR with a vendor, you can't have a BCR of Microsoft or Google. That is not the way this measure works. So the only thing that is left is standard contractual clauses. And everyone used to sign them. They used to be, a standard addition next to a DPA to a contract you negotiate. So basically, identifying the mechanism is easy. But now we go to the extremely interesting part. Transfer impact assessment. How does this work? It practically would work such that, what Marcel already mentioned, we should look into how Paraguay established a legal system. How is the data protection law? How is, the enforcement? How are the security laws? How likely is it that they are able to take the data that has been exported to this country and, grasp it in a way? And this should be done, again, no joke, by the one lawyer in a startup, by the 10 people in a normal company, which is having 2,000 or 3,000 employees. Or maybe even if you have, I don't know, 1,000 lawyers in a very large European company. They all had other jobs. European Commission can't do it, but we should. So they should do all of this assessment, and then they should basically practically look into, here are their laws, here is the data, I need to understand how all of this impacts each other. It's extremely difficult. How it will most likely end up is that we will have this paper-like exercises in which this is going to be done. At the very end, we will write, okay, this seems okay in this specific case. Now, the companies, you also need to understand, don't really have that much of a choice. There is very little of choice that the company can make. It's not like you can just use another Google or another Microsoft, or that there is a good alternative locally in Europe. There isn't simply. So there is this fight, which is really a fight of Max Schrems and of maybe even a lot of politicians against big tech. What it doesn't really understand that, we can't really allow ourselves, our companies can't allow themselves to get out of GAFAM's products because there's really little that we could use instead. But at the same time, we can't really fix it either. I mean, US and EU can't fix it for themselves. How should this be impacted by a company? So the company has two choices. It can either say, okay, I'm just going to do this paper exercise, and at the end, I'm going to stamp it and say it's fine, or I need to find a different vendor. Typically, they can't find a different vendor, so they need to do the first. They will do this exercise, a massive paper exercise, 100 times, 1,000 times, and at the end, they'll have to say, okay, in this case, we can do nothing but say we're okay. And now the last part probably here is what Marcelo said. Okay, technical contractual supplementary measure. Contractual, well, I'm sorry, you can't contractually override binding laws. So Microsoft, if you want a big company, but also a tiny US startup, will not guarantee to you, hi, we will not obey US law. Microsoft might get into a fight to try to fix that, to try to disregard a court order or disregard a request from security agencies. Sometimes they do, but they will do what they have to do when this is, a final decision. The startup will do so even less. So contracts are out of the question. What could they do? What is at the table is technical and organizational measures, but that typically requires a lot of work, which is fine, but will impact the usability of the solution. So, we're speaking encryption. Yes, but the encryption, we can have encryption at rest. So if you just want to use AWS to, have your data stored somewhere, but it's a completely different story. If you're actually asking an analytics company to run certain operations on your data, then it's a problem. And that's basically why everything here will be extremely, extremely difficult. And again, it has to be done 100 or 1,000 times. So yeah, I think that's probably my main point here, that this exercise can't end up well. This exercise is good for people like me because, I'm a consultant, I come to companies and I can help them run this exercise. But it isn't really positive to me as a data subject because I don't think that as an outcome of it, the protection given to my data when a European company is using an external service provider is increasing in any way. And with this, I can actually give the floor to Kimmo and see what he says on the technical aspects of this. Thank you.
So I will cover some technical approaches that are there attempting to enforce some of the concerns we discussed here. I hope you see my screen now, good size. So I will limit this to just a few illustrations of different approaches. I'll start with the Gaia-X, the European initiative for basically next generation data infrastructure. So it's a massive development initiated by Germany and France, and is addressing a lot of the concerns we have with data in general, and especially data transfers. And this is still very, very much work in progress. So there is general consensus emerging on the technical architecture. There's a number of pilots and a lot of activity ongoing, but I would say that it's quite far from being the norm, how we would go about with all topics data. And we'll see what would be the then outcome and in which time frame. But by and large, the architecture itself supports all these targets that we see here. So the security is enforced by design. Privacy also enforced by design. The entire project is very much about federation, distribution, and decentralization. So going beyond the highly centralized cloud approach. Also, we have guidelines to aim for usage friendliness, keep things simple. So select the simplest approach possible that would do the job. All should be then possible to process by machines, so programmatically. And then we have semantic representation for data. Here, one illustration about the relation between the different participants. So we have here service consumer and we have data owner, and this is pretty significant. And then obviously we have also service providers, service instance providers, and then node providers. But the data owner here, it's a major step forward that this has been clearly defined. So the data owner makes the data available, the different data assets, and those can be then exposed to various service instances. And there's clear agreements basically on how this all works. So what data would be exposed to which services and so forth. This is a massive topic by itself, so we don't have a chance to go to any meaningful level of details here, but you will find plenty of resources, and this technical architecture itself is one of the better places to start if you are interested. Another technical trend, maybe you could call it a mega trend, is edge computing. So basically, it's all about moving things from a vast centralized cloud to edge, or from cloud to fog, as some people say. Like we have used to work this way, that you see on the top, all data transferred to cloud, and then it would go to, in this case, example about Azure, but it's basically the same. So it would be processed in the cloud, and then decisions, actions, reports, all sorts of outcome are then sent back, whether to sensors or to the users or various types of systems. The core idea about edge is that we actually move a lot of this from cloud to the edge, to the sensors. It could be mobile phone, it could be some 5G, 6G network element. Basically things that are more local and closer to the actual user or usage. So basically, the data would be collected locally. It will be stored locally and also processed locally. And here we would have this filter. So highly selected data by factor of 1,000 or even more in data volumes is then sent in any way to cloud, facilitating then the usage of other systems and services in the ecosystem. This also extremely interesting, and I think it's right to call this really the next wave in data ecosystems, but very, very much work in progress. So under research and only very limited number of pilots and initiatives currently going. Then the last part, and the one that I spent most time here, about Prefina. So that's a company I'm associated with. And we have taken maybe one step further. So we put the individual in the middle. So this is one of the key theses that we have for the Prefina proposal. So obvious question, every one of us, we have more data about ourselves than even the biggest platforms. And all these developments that we've discussed before, they basically are advocating the individual's access to data about them. So you, me, everybody can ask for our own data. That's already part of the GDPR, which is widely accepted as the globally leading norm in its field and being taken into use in various forms, CCPA in the US, and same kind of developments all over the world. So Prefina's sort of mission is then to enable accessing all that data in the various cloud-based services owned by the big platforms, or even can be smaller, more niche service providers. Get the data to the individual's personal data cloud, so completely personal, completely owned by the individual, and no direct access to that by anybody else but then the individual. And then give the access to various apps, services, the whole ecosystem, the whole world around us via this cloud, and make the data that helpfully all these guys have collected about us, make it available, but under our own terms and conditions. And what we are doing at Prefina at the moment, so building developers, the framework for then using this data strictly under the individual's ownership and their control. So some of the steps here: unlocking the data now in the platforms, collected via APIs. Increasingly there's programmatic access, but sometimes you need to access via simply demanding the data to be sent to you via email or whatever is the format. But then when you have the data, create the data layer, and then link it to the value ecosystem for then various apps and services that you choose to interact with. And here, the first, the data connections that are currently being used, API connections, user uploads using software robots, robotic programming applications. So automating basically the process. Then the data sources to the layers, the modeling and aggregation of data would take care then also in the personal data cloud, basically using key tools, GraphQL, and open source models. And this in a little bit more detail. So from the source data in the platform to the raw data. So basically combine the data from different sources, consolidate it, denormalize, and make it sort of compatible and understandable. Then aggregate it and create profiles, simply data points that are usable for external users. Raw data is actually quite boring, and volumes are vast. Not many services and applications are interested about raw data as such. It's a profile data that creates real value. And when the individual makes that available to the world around us, then it's a lot better for the app and service development. And also this way we can control much easier what data is being shared and used by which services. So just a few quick examples of different approaches in tech, how to enforce basically better control on data transfers and also more generally on future data ecosystems. So thanks from my side.
Great. So first of all, thanks to all of the speakers for your illuminating presentations. As a matter of procedure, I would like to invite people who are watching this webinar on Facebook to comment on Facebook platform, and people who are connected on our platform to send messages directly to the speakers so that we can, ask for their responses to the questions. But maybe I think I could summarize this discussion that on one hand, Schrems' decision has led to kind of a huge wave of dissatisfaction and frustration in terms of compliance, regulatory burden for companies, big and small. And at the beginning, it feels like we are kind of reaching the dead end, that there is no way out. But I think from Kimo's presentation, we can see that the situation is not so dire, and there are some technical solutions that are coming up from the market, and probably gives us some hope. So probably that would be my takeaway. The question is how far and how quickly the European regulation and the global regulatory framework will catch up, and how far and how quick technologies will be able to evolve so that we can probably find alternative solutions to this data transfer. So while we are collecting the responses, I would probably like to ask Marcelo and Magdalena maybe to share your initial thoughts. Do you have any kind of responses to each other's presentations?
Yeah, sure. I don't know. Would you like to start, Magdalena, or I should just go ahead and say something?
Well, Marcelo, my whole presentation was a response in principle to your presentation. So maybe go ahead, and I can totally then just complain and argue that I disagree. I can only say, Paul, that I have one comment to what you just said. I think my problem with this is really that it's a huge formalistic burden for very little gain to data subjects. And that's my main point. like, I don't think companies should be complacent about data protection, but I think the regulator must, whenever they put a burden on an organization, they should think, what is the actual protection I'm giving to someone? I don't see much protection here.
Marcelo?
Yeah, thank you, Magdalena. Just a couple of takeaways from all the presentations that we had today. So I think there are two different issues here. One is the typical kind of small company setup, which it was also presented by Magdalena, right? Where you have to comply with this data transfer mechanism, which is very difficult, as we found out. So that's one issue. And then you have the big tech companies, such as social media companies, that they have all our data. And what I learned from Kimo's presentation is that I think there are some technical solutions for that, right? So you don't really need to transfer. I was always wondering, if you set up a huge subsidiary in Ireland, why do you actually need to transfer data from Ireland to the US, right? So it seems to me that they just don't want to do it. They have this approach in the US and the laws in the US, and they also, I think they feel forced to comply with this Patriot Act and FISA and so on. So this is why they don't come up with clever technical solutions, right? So what I learned from Kimo is that basically we have this concept of cloud, right? And like a metaphor is up there somewhere in the sky, and you cannot really see it, and it's very volatile. But new technologies are bringing down the cloud to the fog, right? And this is the other metaphor. The reason why you call it fog is like in the rainforest, you can see the fog, and it's more at your eye range, right? So you can see it, you can touch it. So all these new technologies and the so-called edge technology are bringing down the data to the applications and the tools used by the end users. So it seems to me that there are some technical approaches for that, and I just don't see big tech companies willing to change that, because it's probably not convenient for them either, right? To give
absolutely
to end user. So that's my conclusion, right? And maybe Kimo can also comment on that as well.
Yeah, quick comment. So you can say that the cloud begets the platforms, and edge probably begets then something new. We don't quite know yet what that might be, but for sure that would be more decentralized, more transparent, and most likely, if we get it right, more enforceable with regards to data transfers and all things related. So that's really exciting. And for that reason, also you're right that we can expect a lot of resistance and delay tactics, and even direct confrontation from some of the biggest players, while some others probably choose to adapt. I'm trying to work out, for instance, what Google is really after in their flock paradigm. Basically, lots of processing taking place in the browser, or Chrome browser for sure. So that is a step towards this kind of decentralized processing, but probably there's also many other threads in their plans. But exciting. We'll see where this takes us.
Great. I think for me, the inner question is how can we make this positive change happen faster? Maybe Kimo can share his thoughts. Where can we find this, force that could lead to the change that we want to see. We see that technologies are there. On one hand, there is much potential, but we also see that big data silos are not really keen on changing their businesses and the technological architecture. So how can we, force this change happen?
Well, I think there's no single and short solution for that, but follow all these developments, both on the legal framework side and then on the technological, the three examples I gave. So obviously Edge and Gaia X and similar kinds of initiatives. And of course, I'm proud about what we are doing at Frifina. So hopefully we can also advance this movement from our side.
Mm-hmm.
It's a cool comment that, it's basically the technology that is very often a solution, and pushing technology that actually convinces people to then push towards, a different setup. And I think that's a very beautiful thing, because it ultimately means that, it's the technology which was the source of the problem in some way. And, the whole combination of data and amassing of data by the big companies. But it is also that becoming a solution which just counterweights that. And I am very hopeful, as a data subject, I'm very hopeful exactly for that, for any solutions that give me back the control over where my data goes.
Mm-hmm. I think we can see that probably some potential we can actually expect to happen from the same GDPR. Oftentimes they make this analogy between GDPR and PSD2, Payments and Services Directive, which unlocked a lot of financial data and led to the fintech revolution in Europe. We can only hope that this right of access to get master copies of personal data held by big data companies could cause a similar ripple effect in data market. But of course, I think the other side of that is how do we go beyond the mere exercise of data rights conferred by public law instruments such as GDPR to something that is more, individual-oriented, user-focused, and also could facilitate companies to provide a better product, better service, that would be more tailored to the individual and user. So I think I would like to see there was one comment coming to us. Magdalena, how do you feel? What is the sentiment between businesses that have to comply with the Schrems and the GDPR? We know that it is really expensive and heavy lift for them to carry. But what is the expectation now? We know that there is very little benefit compared to the cost. So what is the expectation? What do they actually want the Commission first and foremost to do to kind of help a little bit in this situation?
Well, I think clear guidelines on what is sufficient, practical guidelines, new standard contractual clauses that are, fit for purpose, and then just a little bit of confidence that whatever they'll do will last more than Privacy Shield did, because, that is a huge uncertainty for business. And let's say even today, if you go through this exercise, or even if you decide to change your vendor because of that and try to push for, a siloed approach, how long is it going to last? So they really hope for practical, down-to-earth, stable guideline. And we are not getting this. We are not getting this at all from the authorities. That is just my view of things, but I think quite widely shared by practitioners.
Great. Marcelo, do you have any thoughts from your side?
More than thoughts, I have more questions, actually.
Yeah.
I don't know. One thought that more or less, one of the issues that came up also at the end of the discussion is, besides the compliance issue of transferring data, I think this is pretty much connected to ownership of data, who owns the data. So I think the resistance in compliance with all these from big tech companies is that they want to keep more control of data and therefore the ownership of data, right? So I think this is also something that it is very important to discuss. And the question I have for you, Paul, is actually what is your view, because you live in the US, as you seem to be the only one from the whole group living in, you are based in California, right? And you have the new law in California, and also what is your view, because it's also highly political. So do you see companies worrying about this, and how they're implementing this from your side?
I think on a very high level, I can share some of the thoughts that we kind of came across during last few days. So if we compare the compliance between GDPR and CCPA, it seems that for companies it's much easier to comply with CCPA because of this opt-out framework. So once Americans travel to Europe, first thing that strikes our attention is the number of notifications that we see when we are browsing online in Europe, with all of these, cookie consents. And from user point of view, it seems quite unfair to put so much burden on individuals, right? So there is also quite a bit of burden for users. Basically, why would users now have to comply, or not comply, but actually study what are the data collection practices by businesses, right? In the United States, there are less notification than in the European context. And I think it was also probably CCPA was path-breaking regulation, and with this new presidential team, I think the biggest theme and biggest debate will be whether the federal privacy regulation could be actually in the horizon.
Well, can you tell us a little bit more about the opt-out issue? Because that seems to be a key difference from the European system.
Well, as you know, CCPA provides this right for individuals to opt out of sales of data. So probably the logic behind was slightly different. The starting point is slightly different, so that individuals should be able to actually at least say no. We have learned that it is extremely difficult to implement in practice. There are many privacy by design aspects. How do you even portray this button of opting out? How do you inform individuals about this right to opt out? So practical compliance challenges are obvious, but again, the core. I would often say that one of the core features of CCPA that makes it different from GDPR is this focus on sales of data, right? So probably sale
of data. So the opt-out rule is that you can opt out not to sell the data or sell the data.
The users or consumers have the right to opt out of sales of data. So the default is that data is potentially sold by service provider to third parties, and individuals are given this right to opt out. The implementation, if you can imagine, is really difficult also from technical point of view for companies. So very interesting perspective. And I think one more thought with regard to the comparison between the European and American perspective is that really Europeans, as Magdalena actually emphasized, that data protection is a lot about these data privacy rights. Whereas I think in American context, there is a lot more discussion about ethics of AI and responsible use of data. So I think the emphasis is slightly different here. The conversation is slightly different. And also probably it's partly driven because of the, where we are, in California, all of the big companies are collecting data. and the perspectives are slightly different, as you already discussed. Also, that's why we have Schrems. So maybe Kimo also could help. What do you think? What do you think is now? What about those big companies then? Even though there are new
part from me, and I'm so sorry for this, but I need to leave to a next meeting. It was a pleasure, and it's a super interesting discussion, so I'm very sorry to just jump out. But yeah, it was a pleasure speaking to all of you, and more even, it was a pleasure to listening to you. So let's stay in touch, and yeah, good things. Take care. Bye bye.
Thank you, Magdalena. See you.
So maybe we could also move towards the end of our event. Kimo, maybe last word from you.
Yeah, it was about how the big companies, the leading platforms are going to react to this. So I think a lot of guesswork here. Because they are trying to figure out themselves what's the best strategy. We are seeing that in such sort of limited areas like the third-party cookie debacle with Apple, Google, and Facebook having taken very different paths. I guess there's going to be typical development with very large corporates. Some are really facing big difficulties to change. So there's a kind of Darwinism. They are not going to adapt, and they are risking to become obsolete because they have so much existing revenues and vested interests. So they don't want to go cannibalizing that, while others can be more agile and move forwards, finding the right balance. I don't expect the change to really be led by any of the big guys. It seldom happens that those who have the market today are going to be the leading innovators. So we need a lot of also new thoughts and ideas, and then basically promoting the idea. And I think that's going to then show how this all is going to unfold.
Great. So I think we have seen that actually there is quite a bit of hope in the market from the technical and also legal side. There is a political motivation and also business need to look for new, better, more optimal solutions. So I think this webinar has opened some of the new themes for discussion. I would like to thank Marcelo, Kimo, and Magdalena, as well as all our guests for joining us today. And then talk to you soon. Thanks.